Imagine, imagine buying this sprawling, beautiful house. You pay the mortgage every single month. You cover the property taxes. You foot the bill for all the upkeep.
Right.
Legally, the deed is in your name. You own the place entirely. But there's a bizarre catch. The property manager that you hired to look after things has decided to just, well, lock half the doors.
Yeah, just completely off limit.
Exactly.
Yeah.
And when you ask what is inside those rooms or, demand to see the receipts for the maintenance fees you just paid, the manager looks you dead in the eye and tells you it is absolutely none of your business.
It's just a complete inversion of ownership. I mean, you are reduced to a spectator on your own property. You're funding an operation that you are illegally forbidden from examining.
Which is wild. And yet, for over 50 years after India's independence, that was the exact relationship between the Indian citizen and the Indian state.
Yeah, it really was.
Citizens paid the taxes, elected the managers, owned the republic, but were effectively locked out of the house.
Yeah.
The government held all the keys, and secrecy was just the default setting.
Absolutely.
Today, we are breaking down the master key that finally forced those doors open. We're talking about the Right to Information Act of 2005. And if you are prepping for your RTI exam, which I know a lot of you are, our mission today is to serve as your ultimate steady companions for this deep dive.
We're going to make sure you know this inside and out.
We really are. We're dissecting the exact legal mechanics that shifted power from the state back to the citizen. We're covering every critical section, every landmark case law, and, the underlying philosophy you need to master this syllabus.
Right. And to really master the legal mechanics of the RTI Act, we have to first lock down that philosophical baseline.
Makes sense. Where do we start?
Well, in any exam context, starting your answers with the fundamental theory just elevates your argument. The entire concept traces back to the etymology of the word democracy.
Okay.
We were looking at the Greek roots, right? So demo, meaning people, and krates, meaning rule, a government by the people.
The government by the people.
Right. Exactly. And if the people are the rulers, then your property manager analogy holds perfect legal weight. Accountability and transparency are not just nice ideals. They are the structural load-bearing pillars of the system.
Yeah, because a veil of state secrecy doesn't just obscure the government. It actually short-circuits the democratic mechanism itself.
Precisely.
Because if I don't know what the government is doing, I cannot evaluate them. And if I can't evaluate them, my vote is essentially blind. I'm not ruling at that point. I'm just guessing.
You're just guessing. And this realization is why the right to access information is so deeply entrenched in international human rights law. I mean, long before the Indian Parliament passed a statute in 2005, the global consensus was already taking shape.
Like post-World War II, right?
Exactly. After the horrors of the Second World War, where totalitarian regimes just thrived on absolute secrecy and, state-controlled narratives, the newly formed United Nations recognized that information is an antidote to tyranny.
Wow, an antidote to tyranny. That's a great phrase.
Yeah, so the UN propounded these foundational principles for freedom of information, really stressing the concept of maximum disclosure.
Meaning the default assumption is that everything is public, and the government has to, fight to prove why something is to be kept secret.
Correct. That's the baseline. And if we look at the primary text of global human rights, the Universal Declaration of Human Rights of 1948.
UDHR, right?
Right, UDHR. Article 19 explicitly states that the right to freedom of opinion and expression includes the freedom to, quote, seek, receive, and impart information through any media and regardless of frontiers.
Seek and receive. That's interesting.
The words seek and receive are crucial here. It's not just about your right to speak. It's about your right to gather the data necessary to formulate that speech in the first place.
Oh, I see. It puts a positive obligation on the state. They can't just promise not to silence me. They actually have to hand over the data I'm seeking so my speech has some actual substance.
Exactly. And the International Covenant on Civil and Political Rights, the ICCPR, which was adopted in 1966, cemented this by mirroring that exact language in its own Article 19. It turned a declaration into a binding treaty for its signatories.
Right.
And we see this replicated across global coalitions. The Commonwealth, representing 54 nations, issued declarations in the 1980s explicitly stating that public participation in democracy is a mere illusion if citizens lack adequate access to official information.
A mere illusion, yeah.
The Organization of American States, the OAS, they embedded similar binding principles into the American Convention on Human Rights. The global legal framework was pretty unanimous. A citizen's right to know is a fundamental human right.
Okay, so that global framework makes sense post-World War II. But when we look at the timeline of actual enforceable domestic laws, India's 2005 enactment feels surprisingly late. I mean, did it really take countries until the late 20th century to start writing this down in their statutes?
Well, the timeline is historically fascinating because there is one massive outlier, Sweden. Sweden is the undisputed pioneer here.
Really? Sweden?
Yeah. They passed the Freedom of Printing Act in 1766.
Wait, 1766? That is before the United States even declared independence.
I know, it's wild. This was during Sweden's Age of Liberty, which was a period of intense parliamentary power where they explicitly abolished political censorship and guaranteed public access to government documents. It was a radical experiment in transparency over 2 centuries ahead of its time.
That's incredible. So what about the rest of the world?
Well, it took the United States until 1966, exactly 200 years later, to pass their own Freedom of Information Act, the FOIA. And that was largely driven by the public's growing distrust of government secrecy during the Cold War and the Vietnam era.
Right, the 60s. Lots of distrust.
Exactly. And following the U.S., we saw a distinct wave of legislation in the early 1980s. New Zealand passed the Official Information Act in 1982. Canada enacted the Access to Information Act the same year. Australia moved around the same time.
What about the UK?
The United Kingdom, despite its long parliamentary history, only brought its Freedom of Information Act into force in 2005.
Oh, wow. The exact same year as India.
The exact same year.
Okay, so India arrives at the legislative finish line right alongside the UK. But here is the critical gap in that timeline that I think students need to grasp.
Yeah.
If the Indian statute didn't exist until 2005, how were citizens navigating the state before that? Because for an exam on the right to information, we have to look at the Constitution.
Right.
But the founders of the Indian Constitution, drafting in the late 1940s, they didn't actually write the phrase right to information anywhere in the text, did they?
They didn't. The phrase is entirely absent from the explicit text, but the judiciary didn't let that become an excuse for state secrecy.
Okay.
The Supreme Court of India engaged in this remarkable, decades-long process of judicial interpretation to unearth this right from the existing framework. They essentially discovered that the right to know was the invisible scaffolding holding up the explicit fundamental rights.
This reminds me of finding like a dormant developer feature buried deep in a software system's code.
I like that.
Yeah, the original programmers didn't build a massive button labeled right to information on the home screen. So the Supreme Court had to go into the source code, in this case, Part 3 of the Constitution, and prove that without this hidden feature running in the background, the primary apps wouldn't function.
That is a perfect way to look at it.
So which specific articles do they use to unlock this?
They unlocked it primarily through 2 monumental provisions. First, Article 19(1)A, which guarantees every citizen the right to freedom of speech and expression. And second, Article 21, which guarantees the right to life and personal liberty.
Okay, jot those down if you're taking notes. Article 19(1) and Article 21.
Yes. The judicial logic here is a masterclass in constitutional reading. Let's look at 19(1)A first. The core argument is that freedom of speech is hollow without knowledge.
Makes sense.
If the state restricts your access to the facts regarding a public policy or an economic decision or a social program, they are preemptively crippling your ability to express an informed opinion about it.
Right, like you cannot critique a government budget if the government makes it a crime to look at the budget.
Exactly. Therefore, the right to acquire information is an inherent, inseparable precursor to the right to express an opinion.
Okay, the speech connection is clear. But what about the connection to Article 21? Using the right to life to justify demanding government files feels like a much heavier legal lift. How does seeing a bureaucratic memo keep me alive?
It is a heavier lift, absolutely, but it reflects a maturing jurisprudence. The Supreme Court eventually expanded the definition of life in Article 21 far beyond mere animal existence.
Okay.
Life means a life of dignity, health, and meaningful participation in society. So suppose the government is quietly permitting a chemical plant to release toxins into a local river.
Oh, wow. Yeah.
Right. If the citizens living along that river do not have the right to access the environmental impact reports, their physical health, their livelihoods, and their very existence are threatened.
That's a great example.
The courts recognize that you cannot make meaningful decisions to protect your life and liberty if the state monopolizes the data regarding the threats to that life and liberty.
Okay, for anyone studying for the exam, this constitutional evolution is heavily tested. We need to track the specific landmark case laws where the Supreme Court built this doctrine step by step. Let's start at the beginning. What was the first crack in the wall of state secrecy?
The earliest seed was planted in 1950, mere months after the Constitution was adopted. The case is Romesh Thappar v. State of Madras.
Romesh Thappar, 1950. Got it.
The petitioner, Romesh Thappar, was the printer and publisher of an English journal called Crossroads, and this journal was highly critical of the government's foreign policy. The state of Madras, citing public safety and the maintenance of public order, issued an order banning the entry and circulation of the journal within the state.
Wait, they literally banned the physical distribution of criticism?
They did. Just a flat ban. Thappar approached the Supreme Court, arguing a violation of his fundamental right under Article 19(1), and the Supreme Court struck down the state's ban.
Awesome.
Now, while the phrasing right to information wasn't explicitly coined here, the court laid down the bedrock principle. They ruled that the freedom of speech and expression includes the freedom of propagation of ideas, and that freedom is ensured by the freedom of circulation.
Circulation.
Right. If citizens are denied access to publications, their right to receive ideas, their right to know the dissenting views, is violated. This case firmly established that the state cannot arbitrarily shut down the flow of information to the public.
Okay, but Romesh Thappar feels primarily like a freedom of the press issue, right? It's about letting a journalist publish. When does the jurisprudence shift from let the press speak to force the government to open its secret files to the citizen?
That structural shift happens in 1975 in what is arguably the most important foundational case for your syllabus.
Oh, highlighter time. What's the case?
State of UP v. Raj Narain. The historical context here is critical. This case arose from a challenge to the election of the then Prime Minister, Indira Gandhi. Raj Narain, the defeated candidate, alleged corrupt electoral practices. And during the trial, Narain demanded that the government produce the Blue Book, which contained the secret security guidelines for the Prime Minister's travel.
Whoa. That is a massive demand, asking for the Prime Minister's highly classified security protocols in an open court.
Naturally, the government vehemently resisted. They claimed absolute privilege under Section 123 of the Indian Evidence Act, arguing that these were unpublished official records relating to affairs of state, and releasing them would endanger national security.
Sure.
The government's stance was essentially, we alone decide what the public gets to see.
And the Supreme Court rejected that premise.
Justice K.K. Mathew delivered a watershed judgment that fundamentally altered Indian constitutional law. The court forced the disclosure of the required parts of the Blue Book, overriding the government's claim of absolute secrecy. And Justice Mathew penned a paragraph that you absolutely must memorize for the exam. He wrote, "In a government of responsibility like ours, where all the agents of the public must be responsible for their conduct, there can be but few secrets. The people of this country have a right to know every public act, everything that is done in a public way by their public functionaries."
The people have a right to know every public act. I mean, that phrasing alone destroys the colonial mindset of default secrecy. It establishes that the citizen is the principal and the government is merely the agent.
The court explicitly anchored this right to know in Article 19(1). They reasoned that if citizens are to freely express themselves regarding the actions of their leaders, they must be armed with the facts of those actions.
Okay, so moving down the timeline, how did the courts reinforce this after the Raj Narain breakthrough?
2 years later, in 1977, we have the Dinesh Trivedi v. Union of India case. This involved a public interest litigation seeking the disclosure of the Vohra Committee report, which had investigated the criminalization of politics and the nexus between criminals, politicians, and bureaucrats.
A very sensitive report, I imagine.
Very. And the government, again, tried to keep the report under wraps. The Supreme Court ruled in favor of disclosure, observing that in a democracy, open government is the new democratic culture. They invoked the famous Brandeis concept, stating that sunlight is the best disinfectant against the disease of corruption.
Sunlight is the best disinfectant. Love that. Now, I want to pause on the timeline for a moment to highlight a massive confrontation between the executive and the judiciary itself.
Ah, yes.
The 1982 SP Gupta v. Union of India case, commonly known as the judge's transfer case. This wasn't about a journalist or a politician's election. This was about the independence of the courts.
This case is paramount. The context was a period where the executive was aggressively attempting to transfer high court judges who were perceived as inconvenient or independent. The petitioners demanded the disclosure of the correspondence between the law minister, the Chief Justice of Delhi, and the Chief Justice of India regarding the non-appointment and transfer of specific judges. And the executive government threw up an immense legal shield, claiming this high-level correspondence was a protected state secret.
Because if the correspondence was released, it would likely expose the political motivations behind punishing those independent judges.
Exactly. A 7-judge Constitution bench heard the matter. Justice P.M. Bhagwati delivered an extraordinary opinion. He completely rejected the government's claim of privilege. He ruled that open government is the rule and secrecy is the strict exception, justified only where it is strictly required by the public interest.
The rule versus the exception.
Right. He noted that the concept of an open government is the direct emanation from the right to know. The correspondence had to be disclosed. This case proved that not even the highest echelons of constitutional appointments were immune to the citizens' right to information.
Okay, so we mentioned earlier that the courts eventually moved beyond just the freedom of speech argument and linked the right to information directly to Article 21, the right to life.
Yeah.
Where did that definitive legal link happen?
That definitive link was established in 1988 in the case of Reliance Petrochemicals Ltd v. Indian Express newspapers.
1988, got it.
This is a nuanced case. It dealt with a media gag order regarding the legality of a massive debenture issue by Reliance. While vacating the injunction against the newspaper, Justice Sabyasachi Mukherjee expanded the horizon of the right to know. He explicitly recognized it as emanating from the right to life under Article 21.
Wait, how did he build that bridge from a corporate finance dispute to the right to life? That seems like a stretch.
He argued that a citizen's right to life includes the right to participate in the democratic process and the industrial development of the nation. He observed that citizens have a right to know in order to take part in participatory development.
Oh, I see.
Yeah, you cannot have a flourishing democratic life if the massive economic forces shaping the country operate in the shadows. He termed the right to know a basic right which citizens must be guaranteed in a free society.
Fascinating. And the Supreme Court didn't stop at political and economic data either. They pushed this doctrine into areas that affect daily consumer life. Let's look at the mid-1990s.
Yes, in 1995, we see two major expansions. First, in Tata Press Ltd v. MTNL, the dispute was over the publication of the Yellow Pages telephone directory by a private company, which the state-run MTNL tried to block, claiming a monopoly.
The Yellow Pages.
Right. The Supreme Court ruled in favor of Tata Press, holding that commercial speech is a part of freedom of speech and expression. More importantly for our topic, they ruled that the public at large has a right to receive information even through advertising.
So the right to know isn't just about reading a government budget. It's about a consumer's right to access market information to make economic choices.
Exactly. And that same year, in Secretary, Ministry of Information and Broadcasting v. Cricket Association of Bengal, the dispute arose over the broadcasting rights of cricket matches. The government tried to monopolize the telecast.
Oh, wow.
The Supreme Court delivered a landmark ruling on the airwaves. They declared that the airwaves are public property, to be utilized for advancing public good. They explicitly ruled that the right to freedom of speech and expression includes the right to receive and impart information through electronic media, and that citizens have a fundamental right to be informed adequately and truthfully.
Okay, so if the courts are saying citizens have a fundamental right to be informed truthfully so they can make choices, that legal logic has to inevitably crash into the most critical choice a citizen makes, right? Voting.
Yeah.
Which brings us to the early 2000s, right before the RTI Act was drafted.
The jurisprudence reaches its zenith in the voter rights cases. We look at Union of India v. Association for Democratic Reforms, or ADR, in 2002, and PUCL v. Union of India in 2004.
Okay, ADR and PCL.
India was facing a severe crisis of the criminalization of politics. Candidates with massive criminal records and unexplained wealth were routinely winning elections because the voters simply didn't know who they were really voting for.
And the Election Commission tried to mandate disclosures, right? But the political parties united to block it. They passed an ordinance to amend the Representation of the People Act to prevent candidates from having to reveal their pasts.
A classic case of the establishment protecting its secrets.
Seriously.
But the Supreme Court struck down that amendment as unconstitutional. They mandated that voters have a fundamental right under Article 19(1)A to know the antecedents of the candidates contesting elections. Candidates are now legally required to file sworn affidavits declaring their criminal records, their educational qualifications, and their financial assets and liabilities.
Huge.
The court declared that a voter's speech, their vote, is meaningless if it is cast in ignorance. The right to know is the prerequisite for a functional democracy.
The judicial evolution is just brilliant. From 1950 to 2004, the Supreme Court took the abstract concepts of free speech and life and hammered them into a concrete constitutional mandate for transparency.
They really did.
But, a constitutional right, no matter how strongly worded in a Supreme Court judgment, is incredibly difficult for a village farmer or a daily wage worker to enforce. You can't file a writ petition in the Supreme Court every time the local municipality refuses to show you the road repair budget. The public needed a statutory mechanism, like a daily operating manual.
They needed a codified process with deadlines, designated officers, and penalties for noncompliance. The judicial foundation was laid, but the House needed plumbing. That is precisely what the Right to Information Act, 2005, provided.
Let's pivot from the constitutional theory and dive into the hard statutory text of the 2005 Act. For the exam, you need to define the absolute boundaries of the law. Who gets to ask for information, what exactly can they ask for, and who is legally obligated to answer? Let's tackle the who first. Section 3 of the Act sets the baseline.
Section 3 is deceptively simple. It states, subject to the provisions of this act, all citizens shall have the right to information.
Okay, the key word there is citizens. Is a massive multinational corporation or an international NGO wants to file an RTI application to dig up data on a competing government project, can their legal team just mail in a request under the company letterhead?
This is a scenario examiners love to test.
Okay, listen up.
The answer is a definitive no. The RTI Act strictly defines the beneficiary. The right is conferred only upon natural persons, living, breathing human beings who hold Indian citizenship. It explicitly does not extend to juristic persons.
Juristic persons.
Right. A juristic person is a legal entity, like a company, a corporation, a trust, or an association. They might have legal rights to sign contracts or be sued, but they do not possess the fundamental right to information under this statute.
What happens if a corporation tries anyway?
The request will be rejected. The Central Information Commission established the precedent for this in the case of Indergrover v. Ministry of Railways. In that instance, the applicant filed the RTI application in his official capacity as the managing director of a private company. The CIC dismissed it, ruling clearly that corporate bodies cannot invoke the RTI Act.
But practically speaking, corporations desperately need government information for compliance, market research, and bidding on contracts. How do they navigate this limitation?
Through a legally acceptable workaround. While the company itself cannot file the application, there is nothing stopping an employee, a director, or a shareholder of that company from filing an RTI application in their own individual personal capacity as an Indian citizen.
I see.
The public authority has to provide the information to that citizen. What that citizen subsequently does with the information, including sharing it with their employer, is entirely up to them. The critical legal distinction is that the application and the fee must be submitted in the name of the individual natural person.
Okay, that clarifies who can stand at the counter. Now, what are they allowed to ask for? Let's scrutinize Section 2F, which defines information. I assume it covers standard files and emails. But what if the government makes a terrible policy decision, say, routing a new highway directly through a protected wetland?
Okay.
Can I use the RTI Act to demand that the minister write me a detailed explanation of why they chose that route?
You cannot, and this is where many RTI applicants fail. Section 2F provides an incredibly expansive list of what constitutes information. It includes records, documents, memos, emails, opinions, abuses, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, and data material held in any electronic form.
Wow, so it sounds like it covers everything under the sun.
It covers every record under the sun, but it does not compel the creation of new explanations. The right to information is a right to access what already materially exists. It is not an interrogatory tool. You cannot ask a public authority questions that begin with why, how, or what is your opinion on, if the answers to those questions are not already written down in a file somewhere.
We have case law confirming this limitation, correct?
We do. The Bombay High Court ruled on this explicitly in the Secy Pinto case.
Oh, so Pinto.
Right. The court held that the definition of information under the RTI Act cannot include within its fold answers to questions asking for reasons or justifications. If you want to know about the highway routing, you must ask for a copy of the project report, the environmental clearance memos, and the minutes of the meeting where the route was finalized.
Okay, so you ask for the documents that contain the reasons.
Exactly. You are entitled to read the reasoning recorded by the officers at the time, but you cannot demand that the current officers sit down and draft a fresh essay defending the decision. The PIO is a provider of records, not a defense attorney for the department's choices.
What about internal unpublished notes? Say a judge is hearing a complex trial and jots down some handwritten thoughts or a draft judgment on a legal pad before finalizing the ruling. Are those considered public information?
They are exempt. The Delhi High Court addressed this in Secretary General, Supreme Court of India v. Subhash Chandra Agarwal.
Okay.
The court ruled that a judge's personal notes, jottings, and draft judgments are essentially an extension of their internal thought process. They are meant solely for the judge's own use to aid in writing the final pronounced judgment. Therefore, they are not considered a record held by the public authority in the statutory sense and cannot be accessed by citizens.
But certain preliminary police records are accessible, right?
Yes. There is a distinction between judicial thought processes and law enforcement records. Documents like first information reports, or FIRs, and post-mortem reports are deemed public documents and are generally accessible under the Act, provided they don't trigger specific exemptions regarding ongoing investigations, which we will cover a bit later.
Okay, so we know who can ask, and we know they can only ask for existing records. Now, who are they asking? Who is legally bound to open their filing cabinets? Section 2H defines a public authority. I understand this covers the Ministry of Finance, the local police station, the municipal water board, the obvious state apparatus.
Right, it covers all of those. The text defines a public authority as any authority or body established or constituted by or under the Constitution, by any other law made by Parliament or state legislature, or by notification issued or order made by the appropriate government. That is the straightforward part.
But the statute doesn't stop there. And this is where the exam questions get deeply analytical, right? Section 2H extends the definition to include non-governmental organizations and bodies owned, controlled, or substantially financed by the government.
The phrase substantially financed is the absolute battleground. The Act doesn't define what substantial actually means. Is it 51% of their budget? Is it a specific rupee amount?
Yeah, how do they measure it?
Because the legislature left it vague, the courts have spent a decade developing the pervasive control test to determine if a private entity has crossed the line into becoming a public authority under the RTI Act.
How does the pervasive control test work in practice? Let's give the students an example.
Let's analyze a critical 2010 judgment by the Delhi High Court, Indian Olympic Association v. Virish Malik. The applicant filed an RTI seeking information from the Indian Olympic Association and the Organizing Committee for the Commonwealth Games. These bodies argued they were autonomous, non-governmental sports associations, not state departments, and therefore exempt from the RTI Act.
But wait, they receive massive amounts of taxpayer money to host these games.
Exactly. And the court agreed. They ruled that these bodies were indeed public authorities. But the reasoning is what you need for the exam. The court established that substantial financing does not necessarily mean a strict mathematical majority of the budget.
Okay.
The test is whether the funding is so significant that the body practically functions as a tool or vehicle for the executive government's policy, or if the entity would struggle to exist or fulfill its public duties without those state funds. Because the government was pouring immense capital into the infrastructure and operations of these sporting events, the sporting bodies became answerable to the citizens who provided that capital.
So the test looks at the functional reality, not just the corporate registration. If a prestigious private school built on subsidized government land receives an annual multi-crore grant to pay its teachers' salaries, it is transformed into a public authority under RTI, at least regarding how it spends that money.
Precisely. Various high courts have confirmed that private educational institutions receiving substantial grant in aid are brought under the RTI net. But the control must be financial or deeply structural, not merely regulatory.
Give me an example of regulatory control that doesn't trigger the RTI Act.
Look at the Supreme Court's ruling in the Thappar case.
Thappar?
Yes. This involved cooperative societies, specifically cooperative banks. The argument was that because these banks are heavily regulated, audited, and supervised by the government-appointed registrar of cooperative societies, they are controlled by the state and should be public authorities.
I mean, that sounds like pervasive control to me. The government can inspect their books and fire their boards.
But the Supreme Court disagreed. They drew a sharp distinction between statutory regulation and pervasive control. The registrar exercises supervisory, regulatory control to ensure the banks don't collapse, much like the RBI regulates private banks. But the state does not own the banks, does not hold their shares, and does not substantially finance their day-to-day operations. Therefore, cooperative societies do not automatically become public authorities merely because a statute regulates them. The RTI net doesn't capture them.
Interesting. What about hybrid entities like the Prime Minister's National Relief Fund, the PMNRF? It relies entirely on voluntary public donations, but it is managed by the highest office in the country.
This creates a fascinating legal paradox which was addressed in the Shailesh Gandhi case before the Central Information Commission. The CIC examined the structure of the PMNRF and concluded that the fund itself is not a legal entity, a trust, or an independent body constituted by the government. It is essentially a discretionary account. Therefore, the PMNRF as an abstract entity is not a public authority.
Wait, so citizens cannot ask how their donations to the PM are being spent. That seems like a massive loophole.
But the law closes that loophole through the back door. While the PMNRF isn't a public authority, the Prime Minister's office, the PMO, absolutely is. Because the administrative machinery of the PMO manages the fund, all the records, receipts, and disbursement details are held by a public authority. Under Section 2J, the right to information means the right to access information held by or under the control of any public authority. Therefore, an RTI application sent to the PMO demanding details of the PMNRF must be honored, subject to standard exemptions.
That brings us perfectly to the mechanics of Section 2J. We know what information is and who holds it. What are my physical, practical rights once the file is located? Can I just walk into an office and demand to read it?
Wow.
Yes, you literally can. Section 2J defines the tangible actions you can take. It includes the right to physical inspection of work, documents, and records. You can sit in the government office and review the original file. You can take notes, extract specific passages, or demand certified copies of those documents to use as legally admissible evidence.
Does it apply to physical objects or just paper? Like, what if a contractor is using substandard concrete to build a public bridge and I want to prove it?
The Act specifically anticipated that. Section 2J includes the right to take certified samples of materials. You can legally use the RTI Act to demand a physical sample of that concrete, take it to an independent laboratory, and have it tested to expose corruption.
That is amazing.
Furthermore, adapting to the digital age, the section guarantees the right to obtain information in the form of diskettes, floppies, tapes, videocassettes, or through printouts where information is stored in a computer.
The power this gives a single citizen is staggering. However, relying entirely on citizens to file applications creates a reactive system. It places the burden of transparency on the individual's willingness to fight the bureaucracy. But a truly democratic law shouldn't wait to be interrogated. And this leads us to the engine of transparency, the proactive obligations of the state under Sections 4 and 5.
Right. If Section 3 is the right of the citizen, Section 4 is the fundamental duty of the state.
I picture Section 4 like a restaurant's legal obligation to post its hygiene rating, its menu, and its prices right on the front window. A customer shouldn't have to kick down the kitchen door and interrogate the chef just to find out if they serve vegetarian food or if the kitchen is clean. The establishment should volunteer that information to the public domain.
That analogy perfectly captures the spirit of suo motu, or proactive disclosure, mandated by Section 4. The explicit legislative intent behind this section is to ensure that public authorities routinely publish and update so much of their operational data that the public has minimum resort to the use of the formal RTI application process.
So what exactly did Section 4 force the government to put on the window?
The Act gave every public authority a strict deadline, 120 days from the enactment of the law, to publish 17 specific categories of detailed information. This wasn't a vague request to be transparent, it was a granular checklist.
What kind of operational data is on that list of 17?
Well, they must publish the particulars of their organization, its functions, and its duties. They must map out the powers and duties of every single officer and employee so the public knows exactly who is responsible for what. They have to publish the procedure followed in the decision-making process, including channels of supervision and accountability.
So they have to reveal the actual flowchart of how a file moves and who signs off on it.
Exactly. But it goes deeper into the financials. They must publish the budget allocated to each of its agencies, indicating the particulars of all plans, proposed expenditures, and reports on disbursements made. They must detail the manner of execution of subsidy programs, including the amounts allocated and the details of beneficiaries of such programs.
That strikes at the heart of resource distribution and potential graft. If a municipality claims it gave subsidies to 100 farmers, Section 4 demands they publish the names and amounts.
Right. They also have to publish a directory of their officers and employees, along with the monthly remuneration received by each of them, including the system of compensation. The public has a right to know the exact salary of the civil servants they employ. This massive data set must be updated every year, it must be widely disseminated in local languages, and it must be available in easily accessible and cost-effective formats.
There is one specific subclause in Section 4 that I think fundamentally alters administrative law, and that's Section 4.1d.
Yes. Section 4.1d mandates that public authorities provide reasons for their administrative or quasi-judicial decisions to affected persons.
This is revolutionary. Before RTI, if a government department rejected your pension application or denied your business license, you would just receive a generic rejection letter. To find out why, you'd have to bribe someone or file a lawsuit. Under 4.1d, the authority is statutorily commanded to proactively explain their reasoning to you. You don't even have to file an RTI to get the why if you are the affected party.
That is the theory, yes. To execute all this disclosure and to handle the inevitable RTI applications when the proactive disclosure isn't enough, the state needed designated personnel. An anonymous bureaucracy cannot be held accountable. A specific officer can. This is governed by Section 5.
So who manages the applications?
Section 5 required every public authority within 100 days of the enactment to designate officers as Central Public Information Officers, CPIOs, or State Public Information Officers, SPIOs, in all administrative units or offices. Yes, these PIOs are the crucial nodes. They are legally mandated to receive the request, process them, locate the information, and provide it to the citizens. To ensure accessibility in far-flung areas, the law also mandated the appointment of assistant PIOs at subdivisional levels, acting as local receiving points.
Let's analyze the role of this PIO. Bureaucracies are hierarchical and defensive. If I file an RTI asking for a controversial file, and the PIO asks their department head, and the department head says, absolutely not, do not give them that file, can the PIO just write back to me and say, sorry, my boss said no?
The courts have aggressively shut down that excuse. The role of the PIO was legally defined in the landmark Delhi High Court case of J.P. Agrawal v. Union of India.
J.P. Agrawal.
Right. The court observed a disturbing trend where PIOs were merely acting as forwarding agencies. They would send the application to a subordinate or superior, receive a one-line rejection, and blindly forward that rejection to the citizen.
Treating their office like a mailroom.
Precisely. The court coined a phrase to stop this. The PIO is not a mere post office. The judgment made it explicitly clear that the PIO bears an independent statutory responsibility. When a request lands on their desk, they must apply their own mind independently to the provisions of the RTI Act.
Wow.
Yeah, if a superior tells them to hide a document, but the document doesn't fall under any legal exemption, the PIO is legally bound to release it. If they blindly forward a baseless rejection, they personally are the ones who will face the penalties, not their boss. They are the guardians of the act within their department.
Right. The architecture is in place. We have the definitions, the proactive duties, and the designated officers. Now we must walk the listener through the actual practical mechanics of pulling the lever. How do you file a request? And how long does the government have to respond? We are looking at Sections 6 and 7. And I will admit, whenever I think of engaging with a government bureaucracy, my stress levels spike. I imagine complex legal forms, notarized affidavits, and indifferent clerks rejecting my paperwork because I use blue ink instead of black. Do I need to hire a lawyer to draft an RTI? Do I have to write a compelling essay proving I have a noble reason for wanting the information?
The genius of Section 6 is its deliberate, radical simplicity. The drafters knew that if the process was legally complex, the rural poor would be excluded entirely. You absolutely do not need a lawyer. The request simply needs to be in writing or through electronic means. It can be drafted in English, Hindi, or the official regional language of the area.
What if someone can't write?
If a citizen is illiterate or cannot write, The PIO is legally bound to render all reasonable assistance to reduce their oral request into writing.
What about the justification? If I ask the municipal corporation for the architectural blueprints of the mayor's newly renovated office, won't they demand to know why I am scooping around?
This is the most empowering clause in the entire Act, Section 6.2.
Yeah.
It explicitly strips the government of the right to ask why. It states that an applicant making a request for information shall not be required to give any reason for requesting the information.
That's amazing.
The government is not allowed to judge your motives. Furthermore, you are not required to provide any personal details beyond what is strictly necessary for them to contact you, usually just a name and a mailing address.
I can literally just write, I am a citizen, give me the file regarding the mayor's office renovation. Here is my address, and they must comply.
Yes, though practically you must specify the exact documents you want to avoid receiving boxes of irrelevant paperwork. In fact, Central Rules subsequently established a 500-word limit for the application to force applicants to be concise and prevent rambling grievances.
Okay, here's my nightmare scenario. The government is a labyrinth. I want data on a rural health clinic. I spent hours researching, and I mail my 500-word RTI application to the Ministry of Health in Delhi. A month later, I get a letter back saying, sorry, this clinic is managed by the State Health Department. Request denied. Go away. I have just wasted a month.
The drafters anticipated the wrong department defense and neutralized it in Section 6. Under the RTI Act, the burden of navigating the labyrinth is shifted from the citizen to the state. If you send an application to Public Authority A, but the subject matter is actually held by Public Authority B, Authority A is legally forbidden from just rejecting your application.
So what must they do?
They are statutorily bound to transfer your application, or the relevant part of it, to the correct public authority. And they must do this rapidly within 5 days of receiving it. Crucially, they must immediately inform you in writing that your application has been transferred, providing the contact details of the new PIO handling it. The government has to find the right desk for you.
That completely eliminates the jurisdictional runaround. So I've filed my concise application, and it is on the correct PIO's desk. The clock starts ticking. How long do I have to wait? Section 7 governs the disposal of requests. What are the deadlines?
Section 7 sets rigid statutory clocks, and the system depends entirely on them. The standard time limit for a PIO to either provide the information or officially reject the request, citing a specific exemption, is exactly 30 days from the receipt of the application.
Are there any variables that change that 30-day baseline?
Yes. If you submitted the request to an assistant PIO, who acts as a local receiver, the law gives them an extra 5 days to physically forward it to the main PIO. So the timeline becomes 35 days. Also, if the request involves information provided by a third party who claims it is confidential, the PIO has to issue notices and hold a hearing, which extends the maximum timeline to 40 days.
But what if waiting 30 days defeats the entire purpose? What if someone is illegally detained in a police lockup? Or a hospital is refusing to release the medical records of a critically ill patient? 30 days is a lifetime in an emergency.
The Act has an emergency override. If the information sought concerns the life or liberty of a person, the PIO is stripped of their 30-day window. They must provide the information within 48 hours of the receipt of the request.
48 hours is incredibly fast for a bureaucracy. Now, regarding fees, access to justice and information often dies at the paywall. Is this system affordable for the average citizen?
It was designed to be highly accessible. The base application fee prescribed by the rules is generally nominal, usually 10 rupees. If the PIO locates the file and it is 50 pages long, they will charge a tiny copying fee, usually 2 rupees per page. So the financial barrier is extremely low.
That's good.
However, even 10 rupees is too much for some. The Act includes a vital social justice exemption. Citizens who are below poverty line or BPL pay absolutely nothing, neither the application fee nor the copying charges. The state subsidizes their right to know.
That ensures equity. But there is another fee exemption in Section 7 that functions as a punishment for the bureaucracy.
Yes, Section 7.6. This is a critical accountability mechanism often tested in exams. If the public authority fails to comply with the specified time limits, if they miss the 30-day deadline, they forfeit the right to charge any fees. Even if the requested information is a massive technical report that costs thousands of rupees to photocopy, if the PIO is late, the information must be provided to the applicant entirely free of charge. The cost of delay is borne by the state.
Speaking of massive reports, let's explore a conflict regarding volume. Let's say an urban planner files an RTI requesting all the interdepartmental communication, draft maps, and feedback data regarding the entire master plan of Delhi for the last 5 years. It's easily 10,000 pages of physical files. Can the PIO invoke Section 7(9), which says information should ordinarily be provided in the form sought unless it would disproportionately divert the resources of the public authority? Can they just look at the mountain of files and say, request denied, this is too voluminous, it will break our printers and stop all our other work?
This exact scenario resulted in a massive legal battle in the case of Sarbajit Roy v. DDA before the Central Information Commission. The applicant asked for massive amounts of feedback data. The Delhi Development Authority flatly refused, citing Section 7(9) and claiming it would disproportionately divert the resources. The CIC had to interpret the exact wording of that clause.
How did the CIC rule?
The CIC ruled definitively against the DDA. They clarified that Section 7(9) is not an exemption from disclosure. A public authority cannot outright deny a request just because it is massive. The substantive right to the information remains absolute. Section 7(9) only allows the authority to change the form in which the access is provided to protect their resources.
So they can't say no. What alternative form can they offer?
Instead of forcing their staff to stand at a photocopier for a week making 10,000 copies, the PIO can invite the applicant to their office, set them up at a desk, and provide the original physical files for inspection. The applicant can then read through the mountain of files and identify the specific 20 pages they actually need copied. The burden of sifting through the volume is shifted to the applicant, but the access to the data is preserved.
That is a brilliant balance. The government cannot hide behind administrative inconvenience. However, the government will not always say yes. We know they have 30 days to reply, but sometimes they raise a shield. This is where we enter the most fiercely contested battleground of the RTI Act, the exemptions under Sections 8, 9, 10, 11, and 24. For a student, mastering this section is non-negotiable.
This is where the friction happens. The exemptions are the legal defenses the state uses to maintain secrecy.
The default is disclosure, but Section 8(1) is a list of authorized secrets. I like to think of Section 8 not as a bouncer at a club arbitrarily denying entry, but rather as a triage nurse in an emergency room. The nurse's job is to weigh immediate, severe harm. Releasing government information is generally healthy for the democracy. But the triage nurse has a checklist of 10 specific conditions where releasing the information immediately would cause catastrophic harm to the state, to society, or to an individual's safety. The PIO has to prove the requested file has one of those 10 conditions. Let's walk through the checklist. What is the first condition for secrecy?
The most prominent is 8(1)A. This exempts information, the disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, or relation with foreign states. This is the classic national security exemption, troop deployments, nuclear codes, sensitive diplomatic cables.
That seems universally accepted. But bureaucracies love to stretch definitions. Can high-ranking officials use this clause to shield themselves from accountability just because of their position? Say I want the travel expense reports of a state governor. Can they claim 8(1)A because they represent the sovereignty of the state?
They cannot. The courts have drawn a sharp line regarding the governor's constitutional immunity under Article 361. The courts have clarified that while a governor enjoys immunity from judicial proceedings for their sovereign official acts, their administrative or non-sovereign functions, like their office's expenditure, staff appointments, or travel bills, are completely subject to the law of the land, including the RTI Act. A high office does not automatically equal national security.
Good to know. What are the structural exemptions?
8(1)B protects the judiciary. It exempts information which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. You cannot use RTI to bypass a judicial gag order.
Right.
And 8(1)C protects the legislature. It exempts information, the disclosure of which would cause a breach of privilege of Parliament or the state legislature.
Okay, those protect the organs of the state.
Yeah.
What about protecting private enterprise? If a pharmaceutical company submits the secret chemical formula for a new drug to the government health regulator to get safety approval, can a rival company use the RTI Act to legally steal that formula?
The law anticipated industrial espionage. 8(1)D exempts information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party unless the competent authority is satisfied that larger public interest warrants the disclosure.
But the interpretation of commercial confidence triggered a massive legal war regarding the education system, didn't it? Educational boards tried to claim that student exam papers were trade secrets.
It was a fascinating, desperate argument by the examination bodies. It led to the Supreme Court case, CBSE v. Aditya Bandyopadhyay. Students filed RTIs demanding to see their evaluated answer sheets to check for grading errors. The CBSE refused, arguing that the evaluated answer sheet, along with the marking scheme, constituted commercial information and intellectual property held in confidence.
They were trying to monetize secrecy. How did the Supreme Court dismantle that?
The court utterly rejected the premise. They ruled that an examining body does not hold student answer sheets in commercial confidence. The relationship between a student and an examining body is not a commercial transaction where trade secrets are exchanged. The court affirmed that students have a fundamental right under the RTI Act to inspect their evaluated answer books.
That's huge for students.
Oh, absolutely. And a similar, equally important ruling happened in ICAI v. Shanak H. Satya, where the Supreme Court mandated that examination bodies must disclose the question papers, model answers, and marking schemes after the examination process is entirely complete. The transparency of the testing process overrides the board's desire for administrative secrecy.
That was a monumental victory. Now, what about relationships built on absolute trust? Clause 8(1)(e) exempts information available to a person in a fiduciary relationship. I understand a doctor-patient or a lawyer-client relationship. But does this apply within the government?
It does, but it is frequently misunderstood and misapplied by PIOs. A fiduciary relationship is one based on extreme trust and good faith, where one party acts for the benefit of another. But the courts clarified a crucial nuance regarding who actually owns the shield of exemption. The exemption belongs to the beneficiary of the information, not the creator.
Explain how that works in practice.
Suppose a citizen submits their highly confidential medical history to a government hospital for treatment. The hospital holds that information in a fiduciary capacity. If a third party files an RTI asking for your medical records, the hospital must invoke 8(1)(e) to reject it. They are protecting you.
Makes sense.
However, if you file an RTI asking for your own medical records, the hospital cannot invoke 8(1)(e) against you. They cannot say, we hold this in trust, therefore we won't show it to the person who trusts us. The fiduciary shield protects the vulnerable party. It cannot be weaponized against them.
Let's look at exemptions protecting physical safety in law enforcement.
Clause 8(1)(g) exempts information, the disclosure of which would endanger the life or physical safety of any person, or identify the source of information or assistance given in confidence for law enforcement or security purposes. This protects whistleblowers and undercover informants.
Okay.
Clause 8(1) is the police exemption. It protects information which would impede the process of an ongoing criminal investigation or the apprehension or prosecution of offenders.
Because if a suspect can use RTI to read the police case file before they are arrested, they can destroy evidence or flee.
Exactly. But notice the word impede. Once the investigation is complete, the charge sheet is filed in court, and the trial concludes, the justification under 8(1) evaporates. The police cannot permanently hide an investigation file just because it was once an active case.
What about the highest levels of political decision-making? The closed-door meetings where ministers argue over policy.
Clause 8(1) protects cabinet papers, including records of deliberations of the Council of Ministers, secretaries, and other officers. The logic is that ministers must be able to debate frankly and propose unpopular ideas behind closed doors without fear of immediate public backlash.
So the inner workings of the cabinet are permanently sealed.
No, the drafters included a vital caveat. The exemption is temporary. The clause states that once a final decision has been taken and the matter is complete or over, the reasons for the decisions and the material on which those decisions were based must be made public. The internal debate is protected, but the final outcome and its underlying reasoning belong to the citizens.
The final, and perhaps most heavily litigated exemption is 8(1)(j), personal information.
This is the eternal friction point between the right to information and the right to privacy. Clause 8(1)(j) exempts information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause an unwarranted invasion of the privacy of the individual.
How do the courts define the boundary between a bureaucrat's public life and their personal privacy? Like, can I ask for the performance reviews or the tax returns of the civil servant who denied my license?
That specific scenario was settled in the Supreme Court case Girish Ramchandra Deshpande v. CIC. The applicant demanded copies of all memos, show cause notices, censure or punishment orders, and the income tax returns of a specific government employee. The Supreme Court ruled against the applicant.
Interesting.
They held that an employee's performance records, disciplinary proceedings, and income tax returns are strictly personal information. Just because someone works for the government does not mean their entire personal and financial life is a public record. Unless the applicant can prove that a larger public interest justifies the disclosure, the privacy of the employee is protected under 81J.
But that caveat, unless a larger public interest justifies it, is the ultimate trump card in the entire act, isn't it? What if a journalist has credible evidence that the government employee in the Deshpande case is running a massive corruption ring, and their tax returns would prove they possess assets grossly disproportionate to their known income? Does the privacy shield still hold?
That brings us to the master key of the RTI Act, Section 8.2, known as the Public Interest Override. This is a spectacular piece of legislative drafting. It states that notwithstanding anything in the Official Secrets Act, 1923, nor any of the exemptions contained in Section 8.1, a public authority must allow access to information if the public interest in disclosure outweighs the harm to the protected interests.
The triage nurse analogy is perfect here. The nurse sees that releasing the tax returns causes harm to the bureaucrat's privacy. But the nurse must weigh that against the catastrophic harm of allowing systemic corruption to rot the government. If the public interest in exposing corruption is heavier, the privacy exemption shatters.
Exactly. It forces the PIO, and subsequently the courts, to physically weigh the scales of justice in every single denial. The exemptions are not absolute brick walls. They are conditional shields that fall away when transparency is the greater moral imperative.
Does the shield also fall away over time?
It does. Under Section 8.3, the time limit clause, there is a sunset provision for secrets. Generally, any information relating to any occurrence, event, or matter which has taken place 20 years before the date of the request must be provided. Historical transparency overrides present-day sensitivity, with a few enduring exceptions for deep national security.
Okay, let's explore a practical complication regarding exemptions. Section 10, the principle of severability. Let's return to the Aditya Bandapati case, where the student won the right to see their evaluated answer sheet. What if the examiner who graded the paper is terrified that the student might track them down and physically attack them for giving a low grade? Releasing the answer sheet reveals the examiner's signature, which endangers their physical safety under 8.1G. Does the PIO reject the entire request to protect the examiner?
The PIO cannot reject the entire request. Section 10 dictates that if a requested document contains both exempt and non-exempt information, the PIO is legally required to sever or redact the exempt parts and release the rest. In the answer sheet scenario, the Supreme Court ruled that the examining body must physically mask, black out, or redact the name, signature, and identifying details of the examiner to protect their safety under 8.1G. Once the exempt information is severed, they are compelled to hand the rest of the evaluated answer sheet to the student.
The scalpel instead of the axe. Keep the secret, release the data. Now, what if the information I am requesting doesn't belong to the government at all, but was submitted by a private third party? Say I ask for a copy of a lucrative contract the municipality signed with a private construction firm. The firm considers their pricing strategy confidential.
This triggers Section 11, third-party information. The law ensures natural justice. If the PIO intends to disclose information that was supplied by a third party and treat it as confidential by them, the PIO cannot unilaterally release it. They must give written notice to that third party within 5 days of receiving the request. The third party is given 10 days to make a representation, a hearing, arguing why the information should be kept secret under one of the Section 8 exemptions, usually commercial confidence.
Does the third party have a veto? If the construction firm says no, does the PIO have to obey?
They absolutely do not have a veto. The PIO must listen to the objection, but the final decision rests with the PIO. And under the precedent established in R.K. Jain v. Union of India, the PIO can overrule the third party's objection and order disclosure if they determine that the public interest in transparency outweighs the private party's desire for confidentiality.
Before we leave the exemptions, we must talk about the spies. Section 24 deals with intelligence and security agencies. Do the Intelligence Bureau or the Research and Analysis Wing, RAW, have PIOs processing public requests for their operational files?
Section 24 provides a blanket exemption to specific intelligence and security organizations established by the central government, which are listed in the second schedule of the Act. The Act, in its entirety, simply does not apply to them. They operate outside the transparency net.
Total darkness.
Total darkness, except for two massive, heavily litigated loopholes. The darkness breaks if the requested information pertains to allegations of corruption or allegations of human rights violations within those agencies. If an applicant alleges corruption, the agency must process the request. If they allege a human rights violation, the agency must forward the request to the Central Information Commission, and if the CIC approves, the information must be provided within 45 days. The state is permitted to keep secrets, but it is not permitted to keep corrupt or abusive secrets.
We've spent a long time analyzing the laws, the clocks, and the shields. But what happens when the system breaks? A citizen files a perfect request. No exemptions apply. But the PIO simply ignores it or maliciously rejects it, claiming a fake exemption. Where does the citizen go? Do they march down to the local police station to file a theft report for stolen data? Do they hire a high-priced lawyer to file a writ in the high court? We need an accessible referee. This brings us to the appellate machinery and the enforcement teeth of the law. The information commissions under sections 12 through 20.
The drafters knew the bureaucracy could not be trusted to police itself. They created an independent, specialized appellate structure designed specifically to enforce the RTI Act. Sections 12 and 15 established the Central Information Commission, the CIC in New Delhi, and the State Information Commissions, the SICs, in every state capital. These are the apex bodies of transparency.
Who sits on these commissions? Is it just a retirement home for loyal politicians?
The Act strictly forbids political appointments. The commissions consist of a chief information commissioner and up to 10 information commissioners. They must be persons of eminence in public life with wide knowledge and experience in law, science and technology, social service, management, journalism, mass media, or administration. The statute explicitly disqualifies anyone who is a member of parliament, a member of a state legislature, anyone holding an office of profit, or anyone connected with any political party or carrying on any business.
How are they chosen to ensure the ruling government doesn't just pack the commission with friendly bureaucrats?
They are appointed by the president or the governor on the recommendation of a high-level bipartisan committee. At the center, this committee consists of the prime minister, the leader of the opposition in the Lok Sabha, and a union cabinet minister. This bipartisan structure is intended to ensure consensus and independence in the appointments.
For any student of current affairs, we have to address the massive controversy surrounding the terms and status of these commissioners. The 2019 RTI amendment completely fractured the political landscape. What exactly happened there?
To understand the 2019 amendment, you have to understand the original 2005 design. When the RTI Act was drafted, it gave information commissioners a fixed 5-year term. More importantly, it legally pegged their salaries, allowances, and terms of service to those of the election commissioners, who in turn are pegged to Supreme Court judges.
Election commissions are constitutional bodies. They derive their power directly from the Constitution, not just a law passed by Parliament. Why did the RTI drafters link them?
Because they wanted the information commissioners to have absolute, unshakable independence. If an information commissioner is tasked with ordering the Prime Minister's office or the Ministry of Defense to release deeply embarrassing or legally damaging documents, they must be able to issue that order without any fear that the executive branch will retaliate by cutting their salary or shortening their term. Pegging their status to constitutional bodies gave them that armor.
So what did the 2019 amendment alter?
The 2019 amendment rewrote sections 13 and 16. It removed the fixed 5-year term and the salary linkage. Instead, it stated that the term of office, salaries, allowances, and other terms of service shall be such as may be prescribed by the central government.
It handed the power to determine their employment conditions directly back to the executive branch, the very branch the commissioners are supposed to police. What was the government's justification for doing this?
For an exam, you must present the state's argument objectively. The government argued this was merely an administrative rationalization. They pointed out a legal anomaly. The Election Commission is a constitutional body executing a sovereign function, elections, whereas the Information Commission is merely a statutory body created by a specific law to execute a specific administrative function, appeals. The government argued that equating a statutory body to a constitutional body was a drafting error in 2005 that needed correcting to maintain the legal hierarchy of institutions.
And the counter-argument from transparency activists.
The critics argued that this destroys the institutional independence of the commissions. Even if they are statutory bodies, they perform quasi-judicial functions that require them to rule against the highest offices of the government. If the central government holds the power to arbitrarily prescribe their salaries and terms, the commissioners essentially become subordinate employees of the executive. The fear is that the threat of a salary cut or a term reduction will have a chilling effect on their willingness to issue bold pro-transparency orders against the government.
Regardless of how long their term is prescribed to be, once they're sitting in the chair, how hard is it to fire them?
It remains exceptionally difficult, which is their primary remaining armor. Under Sections 14 and 17, an information commissioner can only be removed from office by order of the president or the governor on the ground of proved misbehavior or incapacity. And crucially, the president cannot just sign an order. The president must refer the matter to the Supreme Court. The Supreme Court must conduct a formal inquiry, and only if the Supreme Court reports that the commissioner ought to be removed can the president act.
Okay, the referees are secure in their positions. Let's walk through the actual appeals process. The PIO has rejected my request, and I have 30 days to act. What is step one?
The Act constructs a two-tier appeals process to prevent the Information Commissions from drowning in every single minor dispute. Your first step under Section 19 is the first appeal. This is an internal mechanism. You appeal to an officer within that same public authority who is senior in rank to the PIO. You have 30 days from the rejection to file this.
The logic being that a senior officer might look at the junior PIO's rejection, realize it is legally baseless, and order the disclosure internally without needing an external lawsuit.
Exactly. It's a chance for the department to correct its own mistake. The first appellate authority has 30 days, extendable to 45 days, to make a decision.
But bureaucracies protect their own. It is highly likely the senior officer will simply endorse the junior PIO's secrecy to protect the department. When the internal appeal fails, how do I escalate?
You trigger the second appeal. This breaks out of the department's hierarchy and goes straight to the independent referee, the Central Information Commission or the State Information Commission, depending on the authority. You have 90 days to file this.
When I arrive at the Information Commission for my hearing, facing down a team of government lawyers defending their refusal to give me the document, do I bear the burden of proving that I deserve the information?
No. And this is perhaps the most structurally profound rule in the entire appeals process. Section 19.5 flips the traditional legal dynamic on its head. In any appeal proceedings, the burden of proof that a denial of a request was justified shall lie completely on the Central Public Information Officer or State Public Information Officer who denied the request.
The presumption is guilt on the part of the state.
Mm-hmm.
They have to prove why they broke the default rule of transparency.
Yeah.
I just sit back and watch them try to justify it.
Exactly. The citizen's right is assumed. The state's exemption must be proven.
There is a critical procedural trap here for students regarding how they approach the Information Commission. The Act provides two separate avenues: an appeal under Section 19 and a complaint under Section 18. They sound identical. When do I use which?
This distinction is vital, and confusing them will destroy your legal strategy. An appeal under Section 19 is an adjudicatory process. You use it when your primary goal is to force the government to hand over the specific information you requested. The Commission acts as an appellate court, reviews the denial, and can order the PIO to release the document.
What was a complaint for then?
A complaint under Section 18 is a supervisory and disciplinary process. It is used for systemic grievances or immediate procedural failures. For example, if a department hasn't even bothered to appoint a PIO, or if the PIO flat out refuses to accept your application form, or if they demand an illegal extortionate fee, or if you have credible evidence that they are currently destroying the records you ask for. In these scenarios, you don't file an appeal. You file a direct complaint to the Commission to intervene immediately.
To handle a complaint like destroying records, the Commission needs serious power.
And they have it. When inquiring into a complaint under Section 18, the Information Commission is vested with the powers of a civil court. They can summon and enforce the attendance of witnesses, compel them to give oral or written evidence on oath, demand the discovery and inspection of documents, and receive evidence on affidavit. No record can be withheld from them during this inquiry.
So if I file a complaint under Section 18 because the PIO refused to take my form, the Commission summons the PIO, finds them guilty of violating the Act, and punishes them. As a result of that complaint process, does the Commission then order the PIO to give me the information I originally wanted?
No. And this is the massive trap that applicants and students fall into. This was definitively settled in the 2012 Supreme Court case Chief Information Commissioner v. State of Manipur.
Why not? If the Commission has the PIO right there and finds them guilty of obstructing access, why can't they just order the file released under Section 18?
Because the Supreme Court ruled that Sections 18 and 19 serve distinctly separate jurisdictions. A Section 18 complaint proceeding is strictly disciplinary. The Commission's power under Section 18 is limited to investigating the grievance and initiating penalty proceedings against the officer. They cannot bypass the statutory appeal structure. The court held that if an applicant wants the actual disclosure of information, they must pursue the Section 19 appeals route. You cannot use a Section 18 complaint as a shortcut to get a disclosure order.
So complaints are for punishing bad behavior, and appeals are for getting the documents. Let's talk about those punishments. Transparency relies on deterrence. A bureaucrat won't release a sensitive file unless the pain of hiding it is greater than the pain of releasing it. Where are the teeth of the RTI Act?
The teeth are located in Section 20, penalties. This is what terrifies the bureaucracy. The information commissions have the power to impose personal monetary fines on erring PIOs. If the commission determines that a PIO, without any reasonable cause, refused to receive an application, delayed the response beyond the 30-day limit, malafidely denied the request, knowingly gave incorrect or misleading information, or destroyed the subject of the request, they will strike.
What is the fine? Does the government department pay it out of their budget?
No, the department doesn't pay. The fine is levied personally against the PIO. The commission will impose a penalty of 250 rupees for every single day that the delay continues or until the information is provided, subject to a maximum cap of 25,000 rupees. That money is deducted directly from the officer's personal salary.
A 25,000 rupee hit to a civil servant's personal bank account is a massive deterrent.
Furthermore, if the commission finds persistent or malicious obstruction, Section 20 empowers them to recommend disciplinary action against the PIO under their applicable service rules. This means the commission can instruct the department to initiate proceedings that could stall the officer's promotions or lead to their termination. Additionally, under Section 19(8), the commission can order the public authority to financially compensate the citizen for any detriment or harassment suffered in the process of chasing the information.
If a PIO gets hit with a 25,000 rupee fine by the Information Commission, can they just walk down to the local district civil court, file a lawsuit against the citizen, and get a local judge to issue an injunction stopping the fine?
The drafters closed that avenue of harassment. Section 23 of the Act explicitly bars the jurisdiction of lower civil courts. No court shall entertain any suit or application regarding any order made under this Act. The intent is to prevent the government from tying up citizens in endless, expensive local litigation.
So the Information Commission's word is final.
Final within the statutory framework. However, because the right to information is deeply tethered to fundamental constitutional rights under Articles 19 and 21, the decisions of the Information Commissions are always subject to judicial review by the higher constitutional courts. A PIO or a citizen can challenge a commission's order by filing a writ petition in the High Courts under Article 226 or the Supreme Court under Article 32.
Because the High Courts and Supreme Court have inherent constitutional powers that a parliamentary statute cannot erase.
Exactly. And the legal weight of the commissions was validated in Namit Sharma v. Union of India, where the Supreme Court recognized that information commissions perform quasi-judicial functions. Their orders are not mere administrative suggestions. They are binding legal judgments that must adhere to the rule of law and principles of natural justice.
We've spent this hour building the ultimate theoretical framework. We've covered the constitutional genesis, the structural definitions, the proactive duties, the filing mechanics, the complex triage of exemptions, the burden of proof, and the powerful appellate referees. On paper, this is a masterpiece of democratic legislation. Strict deadlines, the burden of proof forced upon the state, personal financial ruin for obstructive bureaucrats, and civil court powers for independent commissions. But to truly master this syllabus and to understand the law, we have to step out of the textbook and into the real world. This brings us to our final segment, the critical evaluation and realities of the Act.
Moving from the pristine logic of the statute to the chaotic friction of practical execution is always a sobering academic exercise.
Because the reality is often grim. Despite all the brilliant mechanisms we just discussed, I know activists and ordinary citizens who have waited not 30 days, but 3 years for a second appeal hearing at a backlogged information commission. I know people who have been buried in thousands of pages of irrelevant printouts designed to confuse them. Where is this foolproof law breaking down in practice? Your study material highlights 8 major systemic critiques of the Act. Let's interrogate them. Critique 1. The restriction to citizens only.
We discussed earlier that Section 3 limits the right to natural Indian citizens. Legal scholars argue this creates a severe constitutional contradiction. The Supreme Court rooted the right to information in Article 21, the right to life and liberty. Under the Indian Constitution, Article 21 is a universal human right. It is available to everyone on Indian soil, citizens and non-citizens alike.
So if a foreign national is living in India and the government is building a toxic waste dump next to their house, or if they are arrested by Indian police and face trial, they possess the Article 21 right to life, but they are statutorily barred from using the RTI Act to access the environmental reports or their own police files to defend that life. That seems fundamentally unjust.
It is a glaring inconsistency. Critics argue that by restricting the statutory tool to citizens, the Act fails to fulfill the universal constitutional promise of Article 21 for refugees, foreign workers, and non-citizens facing state action within India.
Let's move to critique 2, appointment opacity. We talked about the high-level bipartisan committees selecting the information commissioners to ensure independence.
The committee structure exists on paper, but the reality of a selection process is heavily criticized for being a black box. Vacancies in the commissions are often left unfilled for years, creating massive backlogs that effectively deny justice to appellants. When appointments are made, the process lacks public scrutiny.
And who actually gets appointed?
That is the core of the critique. Despite the statute mandating diversity, calling for experts in journalism, science, and social service, empirical data shows that the overwhelming majority of chief information commissioners at both the central and state levels are retired senior bureaucrats. Civil servants who spent 30 years operating within a culture of state secrecy are suddenly appointed to enforce absolute transparency against their former colleagues. Critics argue this creates an inherent, unavoidable pro-government bias and weakens the aggressive enforcement of the Act.
Critique 3. Parallel bodies. The Act creates central and state information commissions operating simultaneously.
In a federal structure, this is necessary. However, it creates bizarre jurisdictional turf wars. Because you have state and central commissions operating independently with no unified digital architecture, a citizen might file an RTI with a federal agency regarding a project executed by a State Department. The PIOs bounce the application back and forth, and when it reaches the appellate stage, the central and state commissions might point fingers at each other regarding jurisdiction. Meanwhile, the citizen's 30-day clock expires, and the information is lost in the institutional gap between parallel bureaucracies.
Critique 4 is perhaps the most tragic and urgent failure of the entire ecosystem: the lack of protection for information seekers.
It is the darkest reality of the RTI Act. The Act empowers a solitary citizen in a remote village to demand the financial records of a deeply entrenched local corruption syndicate, a land mafia, or illegal mining operations. The Act forces the exposure of the data, but it contains absolutely zero statutory provisions to physically protect the citizen who exposed it.
There is no whistleblower protection built into the law.
None. The PIO is legally required to disclose the name and address of the applicant. When a citizen targets a violent nexus of corrupt politicians and criminals, their identity is entirely exposed to the very people they are investigating. There have been hundreds of documented cases of severe harassment, physical assault, and tragically, dozens of murders of RTI activists across the country. The law arms the citizen with paper, but leaves them entirely defenseless against retaliation.
That is a profound moral failure of the framework. Moving to critique 5, weak internal machinery for enforcing penalties. We talked about the terror of the 25,000 rupee fine under Section 20.
The fine is terrifying if it is collected, but information commissions are appellate bodies. They are not the police. They can pronounce the penalty, but they rely on the erring PIO's own department to actually deduct the money from their salary and initiate disciplinary action. Often, the department quietly protects its officer, ignores the commission's order, and the penalty becomes a paper tiger. The commissions lack a dedicated enforcement wing to execute their own judgments.
Critique 6. Unsatisfactory voluntary disclosure. This is the failure of Section 4 of the restaurant window menu.
Numerous independent studies, notably comprehensive audits conducted by organizations like PRIA, have demonstrated that proactive disclosure is abysmal, especially at the district, municipal, and panchayat levels. Public authorities routinely fail to update their Section 4 manuals. They publish them in obscure formats, bury them deep in unnavigable websites, or simply ignore the mandate entirely.
And what is the downstream effect of an empty window menu?
The downstream effect is systemic collapse. Because the basic operational data isn't proactively published, citizens are forced to file millions of formal RTI applications just to find out routine information, like the status of a ration card or the date of a road repair. This floods the PIO offices with unnecessary requests, completely clogging the machinery and delaying the complex, high-stakes investigations that the Act was actually designed for.
Which feeds perfectly into Critique 7, practical and infrastructural problems.
We mandate that a PIO must locate a specific document in 30 days, but we haven't digitized the records. In thousands of TESOL offices across the country, records are kept in rotting physical files, poorly indexed, stacked in damp record rooms, and managed by understaffed departments. Even a well-intentioned PIO cannot physically locate a 10-year-old land record within 30 days in that infrastructure. The legal mandate of the 21st century collided with the administrative infrastructure of the 19th century.
And the final critique, number 8, is the invisible force that sustains all the other failures, the mindset of the bureaucracy.
This is the deepest root. It is the colonial hangover. For roughly 200 years, the Indian bureaucratic machinery was constructed, trained, and rewarded based on the Official Secrets Act. The foundational ethos was that the state is the master, the citizen is the subject, secrecy is the absolute default, and disclosure is a punishable anomaly. The RTI Act attempted to legally invert that dynamic overnight in 2005.
But you cannot legislate culture.
Exactly. Human nature, institutional paranoia, and entrenched power dynamics do not vanish because a statute is published in the Gazette. Many officials still instinctively view an RTI application not as a democratic duty to fulfill, but as an adversarial threat to neutralize. They instinctively search for the Section 8 exemptions first, looking for any possible loophole to deny access, rather than adopting the philosophy of maximum disclosure.
Okay, let's bring it all home. We have traversed an immense amount of ground today. We started with the Greek etymology of democracy, tracked the global human rights consensus, and followed the brilliant decades-long judicial evolution by the Supreme Court to unearth the right to know from Articles 19 and 21. We decoded the strict statutory boundaries of who can ask, what they can ask for, and who must answer. We mapped the proactive duties, the strict timelines, the complex triage of exemptions, the burden of proof, and the powerful yet deeply flawed appellate machinery. If you have absorbed this lecture, you are more than ready for your exam. You understand the history, the mechanics, the case law, and the critical realities.
The exam will test your memory of Sections 8.1, or the Raj Narain case, but understanding the why behind the law ensures you can formulate arguments that go beyond rote memorization.
Exactly. And I want to emphasize that this is more than just exam prep. You are studying the architecture of accountability. The RTI Act is a lever that physically shifts the balance of power from the state back to the citizen. It forces the exposure of the government's paper trail. It gives you the master key to that sprawling house you own. But before we sign off, I want to leave you with a final provocative thought, something to ponder as you look toward the future of transparency.
The entire ecosystem we just studied, the definitions, the files, the exemptions, relies on one fundamental assumption: the existence of a physical or digital record. The law forces the exposure of the paper trail.
But the architecture of government is mutating rapidly. Think about how decisions are being made right now and how they will be made a decade from now. Bureaucrats and politicians are increasingly conducting official state business on ephemeral messaging apps like Signal or WhatsApp, where texts auto-delete after 24 hours. The record literally ceases to exist. More profoundly, governments are deploying AI-driven systems and neural networks to make administrative decisions, determining who gets a welfare subsidy, predicting policing hotspots, or evaluating zoning permits.
And those AI models operate as black boxes. They ingest massive amounts of data and output a decision, but even the programmers who design the algorithm often cannot trace the exact, weighted logical steps the machine took to arrive at that specific conclusion. The reasoning doesn't exist in a readable file.
See, exactly. The Right to Information Act guarantees your right to read the reasons for an administrative decision under Section 41D. But if an AI algorithm denies your pension, and there is no human email chain, no draft memo, and no recorded debate, what exactly does the PIO print out and hand to you? If the state of the future operates through self-deleting messages and algorithmic black boxes, how does the right to information survive? You might possess the legal master key, but what happens when the state simply stops building doors? It is the existential frontier of transparency, and it will be your generation's legal battle to fight. Thank you for joining us on this deep dive. Good luck on your exam.